Ian, thank you for coming, everyone. Welcome to this Surrey Law Society webinar on key clauses in residential leases. And we have Ian Quayle of IQ Legal Training here to talk us through these. Hello, Ian. And on the next panel that we will be also discussing some the upcoming Surrey Law Society events that we have to look forward to. So as it mentions, private client update on 4th October, continuing that theme with pensions and life policies and estate planning on 5th October, and the Surrey Law Society Legal Awards on 12th October. And as it mentions, you can view the full program on the Surrey Law Society website, link there. And finally, on this slide, that if you want to ask Ian a question during the webinar, then please use the Q&A facility, and you can use this to send anonymously if you tick the send anonymously checkbox. And again, should you wish to speak to Ian at the end of the webinar, please use the raise hand function and we can be invited to talk. And there'll be an assessment survey afterwards, so we're grateful if you would complete that, as you would all have had the notification that this slide is being recorded, and do bear that in mind. And so then I leave over to you, Ian.
Thank you very much, Martin. Thank you, everyone. Good afternoon. Nice to see you. I'm just going to put my slides up. Hopefully you can see them. And we are now able to proceed. So, formally, on behalf of IQ Legal Training and Surrey Law Society, a massive thank you for the invitation today. What I want to do is to scamper through what I think are some key clauses in residential leases, what are causing problems with regard to clients and what's causing problems with regard to potential negligence claims. As Martin was saying, if you have any questions or queries as the presentation proceeds, feel free to drop me a note via the chat facility, and I'll endeavour to deal with questions at the end of the presentation. If we run out of time or you're too shy to raise a question within the presentation, then the final slide has my contact details, and I'm more than happy to take any emails or questions that you've got after the event, and I'll share those with Helen, if I may, who I'm sure will distribute them to anyone that's attended today. I will anonymize questions and anonymized responses. And if you don't want me to share the question or indeed the response, then hey, I'm quite happy to proceed on that basis. So hopefully you're sitting comfortably. Hopefully you can hear me. Hopefully you can see the slides. The first thing I want to do in connection with leasehold transactions is just highlight to you some useful websites. You will all be familiar with the Leasehold Advisory Service website, which contains a wealth of information for you. Do have a look at the leaflet or link to Do You Know Your Lease? One of the things I will be saying today is it's important that we tell clients about the bigger picture in connection with leasehold ownership. And to that end, if we've got information from the Leasehold Advisory Service that can support what we're saying when we're scoping the retainer or when we're reporting on title, that's got to be useful. The second site is probably a site you're not familiar with, the Leasehold Knowledge Partnership. And the thing about this site is it's quite political, very sort of leaseholder friendly. A few MPs are sort of party to it. And what it seems to do is take up the fight for leaseholders in connection with problems that they've got with specific landlords or specific buildings, particularly with regard to fire safety issues and to an extent the Building Safety Act. It's quite political, but quite useful if you've got leaseholder clients who are encountering problems. The third site that I mentioned is the Association of Residential Managing Agents, and this is useful for two reasons. Firstly, there's information on there for clients, in particular a leaflet concerning owning leasehold property, similar to the Leasehold Advisory Service website. In addition to that, there is information for the use of LPE1s by landlords and managing agents, which I'll come on to when I talk about the Building Safety Act before we finish today. So, first things first then, what's causing problems with regard to leasehold transactions? Well, you may or may not know, but I do a lot of work with professional indemnity insurers looking at negligence claims. I do a lot of work with professional indemnity insurance brokers talking about the marketplace, etc. And as a consequence of that, I have my finger on the pulse to an extent about what's causing problems and what's causing claims. And the important point here is leasehold conveyancing causes more claims than other types of conveyancing. Secondly, as far as claims are concerned, they tend to be less and less relating to errors relating to procedure and more errors with regard to communication. So I think it's really important that you look at scoping the retainer and reporting on title in leasehold transactions and make sure that you are watertight in that it's quite clear as to what's being done and not being done on clients' behalf. The second sort of problem area, which is the sort of elephant in the room, is the Building Safety Act 2022. And I'm doing a lot of work with regard to the Building Safety Act 2022. And the more work you do, the more problems you encounter. It's a bad piece of legislation. It's badly drafted. There are guidance notes that run to some 400 pages. There are a numerous amount of regulations, amending regulations, either that are law or to be law in order to try and resolve some of the problems that the Act has generated. And it's a problem. I'm encountering some firms that are not doing leasehold work where there's any slightest hint of a BSA issue. I'm dealing with some firms that are taking the view that we've got to do work because we can't turn leasehold work away, and therefore we've just got to do it even though we don't want to do it. And I'm also encountering firms who are saying we're not going to do it, but we've got files or transactions that are currently live where there are BSA issues, and we're going to have to complete those and get them finalized. Otherwise, we're going to have clients on our back about delaying transactions or jettisoning clients mid-transaction. On talking to insurers, they are now asking questions of firms if they're doing BSA work, asking for the amount of work that you're doing, and also hiking up premiums as a consequence. Average sort of premium hike seems to be between £5,000 and £10,000. They're also inquiring of firms whether they're doing specialist training, and they've got sort of key figures within the firm that are able to do this work. So just bear all of those things in mind. So they're the problem areas. What about recent developments? Well, putting aside the Building Safety Act, we've got a government, I think, that's hell-bent on sort of reform of the residential leasehold sector. And ultimately, I think what the government would like to do is to tidy it up. And if it isn't tidied up satisfactorily, I think what they will do is sort of relaunch common hold. They did that in 2021. You'll have noticed that there's some good guidance with regard to common hold in 2021. I think it was January 2021. We haven't seen an awful lot since then, but I think unless leasehold starts to work, unless landlords bite the bullet with regard to remediation work in connection with the Building Safety Act, etc., common hold might be on the horizon in the future. So what are conveyancers doing at the moment? They're doing leasehold work. Some under protest, some because they have to, some are dodging the Building Safety Act 2022. Interestingly, what government has said with regards to any work that involves the Building Safety Act 2022, it's specialist work, and therefore you can charge additional fees for the work that you're doing in that connection. So just to sort of drill down a little further on some of those points, the important thing here really is this point that I make on the slide about scoping the retainer. It is absolutely essential that you, when you're doing leasehold work, tell clients what you're going to do and what you're not going to do. It's important that you explain to clients the bigger picture, the radical difference between freehold and leasehold ownership, and the risks associated with leasehold ownership. So what are the risks with leasehold ownership? Well, one, you're acquiring a declining value asset. As the term declines, the value of the lease declines. Two, you've got forfeiture provision within the lease that enables a landlord to bring the lease to an end in the event of breach of covenant. And three, significant as far as today is concerned, you've also got a contractual commitment to pay an unascertained or unascertainable ongoing expense, namely service charge. So it's important, I think, that the client understands those issues. It's important the client understands what you're doing and not doing. You're not an accountant, therefore you can't give advice with regard to previous service charge accounts. that are produced for previous service charge years. You're not a construction expert, so you can't look where a landlord certificate is produced, for example, at what the landlord is saying is remediation work that's caught by the Building Safety Act or isn't caught by the Building Safety Act. You're not a fire safety expert, so where there are fire safety issues, EWS1 issues, or issues associated with fire safety and building safety, again, you can't give advice. You can highlight risk, and that's one of the things that I think as a conveyancer you should do, but actually determining the extent of that risk is beyond the retainer. Case law over recent years has shown that it is essential that you tell clients precisely what you're going to do and also what you're not going to do. The next point that I think is important is something called retainer creep. The idea that we have a retainer, we tell clients what we're doing right at the start of the transaction, but as the transaction progresses, we get drawn into things. So in our retainer, we're not going to give advice about landlord certificates or leaseholder deed of certificates, but then we get the landlord certificate or the leaseholder deed of certificate, and we're then required to give advice relating to it. That's dangerous. So as I say, with regard to the retainer, it is essential that we monitor it constantly. And where we're doing work beyond the scope of our original retainer, we advise the client as to what work we're doing. And again, we revisit or reboot the retainer so that we're telling the client the task that we're performing and the limitations with regard to that task. The next point, I've done a lot of work recently about reporting on title and reporting on leases. And I think the lessons to be learned is that in your leasehold transactions, it is critical that you report on the lease, the content of the lease separately. And there are two sort of sub-points to make here. Point number one, you cannot simply give me, if I'm a client of yours, a copy of the lease and say, read it. What you've got to do is say to the client, if you wish, there's a copy of the lease, have a look at it, but here is my explanation of the terms. Here is my translation of the key issues in that lease. So I don't think that you can, in a leasehold transaction, and I would argue in a freehold transaction as well, it could be dangerous, produce just before the client is due to exchange a huge report on title. There was an unreported case where a county court judge, looking at a report on title that was 20 pages long, said that he was finding it difficult to stay awake, having read page 2. And therefore his criticism was how on earth a client could possibly digest the content of that report, given its size, was beyond him. And of course, I am seeing reports on title that are 80, 100, 120 pages in length, and the client is not going to read or digest that. So what we've got to do, I think, is piecemeal feed our client with regard to what our due diligence exercise is generating, interim reports on title, and a report on the lease as a separate document. I think the other thing that we can do, which is useful, is front load the client with information when we're onboarding the client and when we're scoping the retainer. An information sheet to the client about leasehold ownership generally, about some of the resources, which I'll be touching on during this presentation, about the Building Safety Act. All of these things, I think, are really useful to make sure the client is sort of forewarned, as it were, with regard to information relevant to leasehold ownership. This last point on slide is an interesting one. I think our job is to provide information. I think it is to provide an explanation of process, of documents, of what we do and what we don't do. And on the issue of risk, I think as a conveyancer, you're expected to highlight risk. Other than areas concerning title and quality of title, I think we're simply there to tell the client, look, there is some risk or vulnerability here. And in leasehold transactions, certainly with regard to the amount of service charge, certainly with regard to ground rent review provisions, if the lease contains ground rent review provisions, we've got to flag these up for the client to make sure the client is aware of what their vulnerability is. We should also, when we're highlighting risk, draw to the client's attention the resources that can be used for the client or us or specialists to determine the extent of that risk. Just going off piste for a moment, climate change was something I was asked about yesterday. And the important thing with regard to climate change, of course, is that there is now climate change reports available in the marketplace. So it is important that you explain to clients that they are available, It's important that you highlight to the client why such a report might be beneficial to the client. But as to being a climate change expert, despite the Law Society guidance, I would maintain it's impossible for you as a conveyancer to generate expertise on climate change. So all you can do is highlight risk and explain to the client how that risk can be determined by the use of a climate change report. So again, a good example of what I mean by highlighting risk rather than attempting to determine risk. You are, as a conveyancer, a general practitioner, and therefore the client cannot have an expectation that you have specialism unless you're willing to volunteer that you have specialism. The next thing I want to talk about with regard to clauses in leases is CQS guidance. And what CQS guidance, the amended guidance, highlighted was, first of all, the explanation of the bigger picture. What is leasehold ownership? What is the disadvantage of leasehold ownership as to freehold ownership? I would also maintain that in doing that, you're going to explain to clients the support that government has generated for leaseholders. Landlord and Tenant Act 85, Commonwealth Leasehold Reform Act 2002, Building Safety Act 2022, etc. And also explain the problems. CQS guidance highlights some particular clauses that we need to be aware of and warn our clients about. Firstly, the idea of term, the fact that ownership is for a specific period of time and that time declines. And as it declines, the value of the property diminishes or depletes. Clients need to be aware of the 80-year threshold. I know the government has been looking at revising the valuation issues with regard to lease extensions, but currently we do have an 80-year threshold, an 80-year cliff, as it were, where the amount of premium that pays to be paid to the landlord increases radically, where we go beyond that 80-year term remaining. This explanation for liability for unascertained or unascertainable expenditure, I think, is so important. When we're looking at service charge provision in a lease, the client needs to understand that even though service charge accounts have been produced for previous 3 years, even though estimated accounts have been produced by the landlord on a new build, for example, there's no guarantee that these will be fair indicators as to what service charge will be going forward. If the landlord incurs an expense and the lease permits the landlord to recover that expense, then yes, there are certain measures, safety nets for clients, which we'll look at before we finish today. But nonetheless, despite all those measures, despite all those safety nets and appropriate protections for clients, there is always the risk that there is a big service charge bill coming down the tracks like a steam train that's going to hit the client at some point in the future. Yes, there's some protection, but it is protection that is not infinite, and no one can guarantee to a client that the service charge for last year will be the same as the service charge for this year or the service charge for 5 years hence. CQS guidance advises practitioners to check lenders' instructions, and of course you're now required to check lenders' instructions haven't altered before you exchange, and that's particularly important with leasehold transactions given what's happening with regard to the Building Safety Act. When reporting on the lease, it's important, I think, to look at terms within the lease and anything that's vague or ambiguous to draw it to the client's attention. To explain to the client what you think the provision means, but then explain to the client that it is vague and ambiguous and therefore subject to interpretation. The only way of actually, if you have a risk-averse client, satisfying the client's attitude to risk would be for asking the seller to seek that the lease be varied so that the ambiguity or the vague provision is varied so that clarity is provided. It's also important, I think, to highlight to clients any defective provisions within the lease, and again, to suggest to the seller that they seek a variation to the lease before your client proceeds, or to have a look at the Landlord and Tenant Act 1985 and 1987 to see if it's possible to make an application to tribunal to vary the lease with or without landlord cooperation. And then, of course, we've got the protocol guidance, the conveyancing protocol guidance with regard to leasehold transactions. So let's drill down and start thinking about some of the key terms that we're really interested in. The first thing that I'm interested in are the term provisions in the lease. And I've mentioned the 80-year threshold. I would maintain that where a lease term is less than 90 years, I'd be warning my client about the potential for pitfall and problem once we hit the 80-year mark. I'm very interested in asking clients who are buying leasehold property what their objective is, and do be alive to the fact that you might have a client who's taking a lease with an 85-year term who tells you that the flat is a temporary measure and the plan is to sell it in year 6 or 7, in which case I would draw to the client's attention that it may be necessary to extend the lease before sale, or the fact that the lease term is less than 80 years could have impact on marketability going forward. Important to check lender requirements. And I mentioned again the Building Safety Act here, where you're contemplating extending a lease at the moment, be alive to the fact that if you had a lease that was protected under the Building Safety Act with regard to Schedule 8, where you extend the lease, a deemed surrender and regrant would constitute a new lease. That means the new lease is not 2022 Act protected. What you do, according to government, is agree with the landlord provision in the deed of variation that the 2022 Act applies and the Schedule 8 protection applies, notwithstanding the fact that the lease is a new lease. Now, whether landlords are going to agree to that, whether that's safe for subsequent owners or subsequent landlords is a moot point, but that's what government is currently suggesting. Just so that you are aware, there are amending regulations that are currently before Parliament but are not yet law, that will mean that a new lease granted after the 14th of February 2022 in the context of an extension, if the existing lease was a qualifying lease, the extended lease will be a qualifying lease too. There are valuation and marketability problems, of course, with regard to the term of the lease, and therefore when you're acting for a buyer, it is important that the client has that drawn to their attention. Again, I would do that when I'm scoping the retainer or I'm providing a general information sheet to the client on receipt of instructions, and I would repeat my advice, repeat my view when I'm talking to the client in my report on title. The next thing to talk about is ground rent. And you may think, courtesy of the legislation that occurred in June last year, that ground rent is no longer an issue. And of course, it isn't theoretically an issue for new leases, on the basis that a new lease granted after June last year cannot have a monetary ground rent. But of course, what we've got now is a dual regime, in that we've got old leases that still have a monetary ground rent. And therefore, I think it's important that we explain to clients when we're signing an old lease with a monetary ground rent, in essence, the disadvantage that the client is put to as a consequence. The fact that the client could acquire a new lease without such a provision, and therefore there is, as I say, a dual marketplace with regard to leases currently. Another point with regard to ground rent are the issues associated with lease extensions. The position seems to be that if you're extending a lease, you can have a monetary ground rent for what was the remainder of the existing term, but where there is any new term duration, that has to have a peppercorn ground rent or a non-monetary ground rent. The last point with regard to ground rent provisions in leases is sort of a bit of an interesting area and a problematical area. I am seeing landlords that are now incorporating within service charge hidden management or administration fees. And what they're trying to do is say, right, don't have a ground rent anymore, but I want some form of income from the management and responsibility of this development, this block of flats or whatever. So what I will do is I'll build into service charge management or additional management fees. So I'm sort of recovering what was the ground rent via another method. So do watch out for that. Remember, a landlord can't charge management fees unless the lease permits him to do so. But where the lease does permit him to do so, the landlord might want to have a sort of standing charge for management fees of £250 per annum or something of that nature. Well, if it is associated with management relating to service charge, then it's not a demand or a payment for ground rent. The landlord still receives an additional income or additional cash, not calling it ground rent, calling it something else and hiding it within service charge. Just watch out for it. Just make sure clients are made aware of it. The next point that I want to discuss is issues of repair, and we'll come on to the Building Safety Act and repair and remediation work later. But for the moment and for this slide, what I want to do is say to you that, one, of course, you must always be advising clients about their obligations relating to repair under the lease. And ideally, what that obligation is simply to keep in repair to maintain status quo. to warn clients about any reference to improvement or renewal, warn clients where there's reference to repair and condition. This imposes an additional burden on the client. And I think the other important thing to do and the other important thing to say is that clients need to be told about the benefit of survey. I constantly bleat to practitioners about the use of the RICS Consumer Guide to Survey and Valuation. Don't know if you've seen it, I don't know if you've used it, but I would certainly refer clients to the RICS Consumer Guide because it highlights to the client the different types of survey that are available and the benefit of a level 3 survey. No matter what we're doing with regard to Building Safety Act, surveyors are unlikely to tell us about the height of a building or to tell us in any detail about remediation work that is or is not within the scope of the Building Safety Act. But a level 3 survey is going to contain more information about the state and condition of the building, as well as state and condition of the flat or the apartment. So it might give us a heads up with regard to potential problems associated with landlord disrepair, which I'll come on to in a moment or two. So I repeat, the RICS Consumer Guide to Survey and Valuation is a very useful piece of information to give to clients generally. And of course, your advice should be always that the client should have the best survey they can afford. Where the client obtains a survey, you should ask to see a copy of it. And again, there may be issues associated with title or defects in the lease that is drawn to your attention. There may be issues with regard to disrepair and mediation that could tie into what we have to talk about in connection with the Building Safety Act. The next thing is we have to look at insurance provisions in residential leases, and again ask ourselves, what does the lease say? And the important point here is, firstly, that your task is to look at the insurance provisions within the lease, and then to check that there's a policy that covers the provisions that are required to be insured, or the issues that are required to be insured. So there's a question of looking at the terminology of the lease with regard to insurance, and then looking at the policy and policy schedule to see whether or not whoever is obliged to insure has insured. A word of warning: if the clients have a lease that says the landlord insures, but then there's some informal arrangement with regard to the leaseholder or a management company insuring, if there is a problem relating to who has insured and who hasn't, the courts will always look at the lease. So if there are any informal arrangements with regard to, well, that's not going to work with regard to insurance, therefore I'll deal with it, make sure the lease is varied. There was a case a few years ago where the landlord had a block policy. The leaseholder, one of the leaseholders, was required to insure, and the landlord said, well, that's crazy, I'll insure it. And then the landlord sold the reversionary interest, and the buyer, the new landlord, didn't have a block policy. And surprise, surprise, there was a fire. And then there was a court case as to who was obliged to insure. And the judge said, well, the lease says you, Mr. Leaseholder, are obliged to insure, therefore tough. Don't care about any informal arrangements you've got. If the lease says X, then you comply with X. I highlight this point that you need to see the policy and policy schedule. And I would also emphasize, going back to what I said earlier about risk, that where the client is unhappy about the premium that's paid, or there are issues with regard to what's insured or not insured, then the client should be told to seek specialist advice from an insurance broker to provide assistance and guidance. Your task is simply to check what the lease says and to make sure that someone has given effect to the requirements of the lease. Issues as to the value of the building, the sum insured, etc., are way beyond our retainer. But again, important to tell the client that when we're onboarding the client, and to advise the client at the same point in our report on title. One of the things I've done some work on recently are forfeiture clauses in residential leases. And the reason I've been doing some work on it is that leases are being forfeited. Residential leases are being forfeited by landlords on the basis of breaches of covenant by leaseholders. Yes, it's necessary for the landlord either to bring proceedings before court or tribunal, or to get an admission from a leaseholder that there's been a breach. Yes, there are hoops and hurdles that need to be gone through with regard to acknowledging that there's been a breach of the relevant covenant, and then it's necessary to bring court proceedings to get an order for forfeiture. And yes, leaseholders are entitled to relief from forfeiture, but the important point is forfeiture is not an archaic concept within a lease that's interesting for law students. It is a vehicle for ensuring enforcement and compliance with covenants, and is ultimately a means for a landlord to gain possession and indeed a huge windfall. So, is there a forfeiture clause in the lease? Explain to the client what that clause provides, and explain to the client the gravity of forfeiture. I would always tell any residential leasehold client not to admit in correspondence with a landlord that there's been a breach of covenant. And I would explain to a leaseholder that if there has been a breach, the breach needs to be remedied as swiftly as possible. Recent case law is quite interesting. One case in particular, where we had a lady that was going abroad to live for a while and decided that her brother would act as sort of guardian and caretaker for a flat that she was leaving. She asked him to attend the flat to deal with post, mail, etc., and the normal sort of day-to-day issues that can arise with regard to property ownership. And brother kindly volunteered to perform the tasks asked. However, brother failed to do what he was supposed to do. His brotherly duties were ignored. Landlord wrote to leaseholder saying there was some service charge and ground rent that hadn't been paid. There were further communications that became angrier and angrier, culminating in proceedings, culminating in a default judgment, culminating in forfeiture proceedings, and culminating in an order for forfeiture. Client returns from, I think it was the Far East, to find that her flat was no longer hers and applied for relief from forfeiture. And on application for relief from forfeiture, the judge said, if you're going to give someone the responsibility of looking after your flat or apartment, you've got to make sure that they are trustworthy and they're going to do what you're asking them to do. It's not the landlord's fault that your brother failed to do what he should have done, and therefore I'm not going to grant relief from forfeiture in the circumstances, even though this means that you've lost the flat that you acquired years ago. The significance of that case is that the judge said all you needed to do was simply notify the landlord that you were going away, that you had a contact email address, etc., and that the landlord could communicate with you via that method. And I think that's an important point, that clients need to be told that if they are leaving the flat, if they are renting the flat out or whatever they're doing, to make sure the landlord has a point of contact, and to make sure that if there are problems with regard to payment of service charge, payment of ground rent, etc., there is communication with the landlord, and hopefully in those circumstances, the landlord who feels they're not being ignored will perhaps be a little more reasonable with regard to the delay in taking any action. The next thing I want to talk about is landlord development clauses. And again, there's been case law, recent case law, that highlights that a landlord does not need a redevelopment clause in a lease to redevelop. There may be clauses within leases that prevent redevelopment, but you don't need a redevelopment clause within a lease to redevelop. And therefore, I do think it's important that leaseholders are made aware of the fact that planning applications may be submitted to increase the height of buildings, to increase the number of buildings on a development, etc., all of which potentially might be inconvenient as far as the client is concerned. Yes, clients can take up an action against the landlord with quiet enjoyment provisions and non-derogation from grant provisions within the lease, but there is recent case law that says just because there isn't a redevelopment clause in a lease, that does not preclude the landlord from redeveloping. The next thing, which is, again, I'm sure something that crosses your desk on a regular basis, clients who are buying flats or apartments or properties and saying to you that they're interested in Airbnb letting. This is one area where I think you should, in a leasehold transaction, tell the client from the start that the likelihood of an ability to Airbnb let is small. Unless the lease actually confirms that Airbnb letting is permissible, the general consensus seems to be that there'll be a number of provisions within the lease that will prevent or curb such activity. User covenants being the obvious one. Case law suggests that covenant not carrying out trade or business activity would be breached by Airbnb letting. Also, you've got provision with regards to impeding insurance. Airbnb letting will breach nuisance covenants, etc. So I think it's probably best to warn clients on the start when you're onboarding the client and setting out the bigger picture that Airbnb letting is likely to be impossible in connection with this particular apartment. Again, there are notes that accompany today's presentation, and in those notes there's the relevant case law that will assist you in that point. The next thing, again, and I sought a firm earlier this year that now produces an information sheet for leaseholders about keeping pets in flats and apartments. And of course, what does the lease say is the key issue. Does the lease prevent it or permit it or impose limitations? What is a pet? Well, quite interestingly, the courts have said that a guide dog is a pet. And the courts have also said that even if the lease permits pets, general nuisance clauses are likely to forbid dogs that bark or animals that create noise. So again, I think it's important just to let clients know from the outset the potential limitations associated with pet ownership and flats and apartments. The next thing to talk about are user covenants, which I mentioned earlier. And again, just be careful. Always in a leasehold transaction, ascertain client objective. Why is the client buying this flat or apartment? What's the purpose behind it? It might be that it's a buy-to-let investment. It might be it's addressed for a daughter or son who's going to university or an elderly parent. There could be a whole raft of reasons why this residential purchase is proceeding. You need to know about it. Then you need to ask yourself, does the lease permit it? So what does the lease do? The lease might specify that the flat is to be used for residential purposes. It might stipulate the number of occupants. It might highlight what it means by residential use. Again, all of these things need to be carefully considered. With regard to mixed use, there's been a case recently where someone was occupying a flat that had mixed use, so it was work or home use, and the court had to decipher, did that mean it could be used exclusively as a home or exclusively as a workplace? And what the court said was, well, the actual wording of the covenant meant that it could be used exclusively for commercial purposes or exclusively for residential purposes, or a mix, with the landlord being unable to specify whether there was an issue with the type of mix between the two. So again, be careful with that. Also, check your planning issues. Make sure that there is planning permission to permit whatever use the client intends, and also check superior title to see if there are any covenants that would impede tenant use, notwithstanding what the lease says. Moving on, if I can, I want now just to look at some issues with regard to Building Safety Act potential problems and clauses in residential leases. Firstly, it's important to understand that the Building Safety Act has very wide-ranging application. It can apply to any building that contains 2 or more residential units. So don't get the confusion that the BSA only applies to buildings that are more than 11 meters in height or more than 5 stories. The Act potentially applies to any building that contains 2 residential units. Yes, there are specific provisions that apply to buildings that are more than 11 meters or 5 stories in height. And there are also additional provisions in connection with higher risk buildings that exceed 18 meters in height. You need to be aware of that. But as far as the clauses are concerned in residential leases that can cause problems from a Building Safety Act perspective, we're looking at service charge provision. And with regard to service charge provision, there are 2 points to note. Firstly, a lease should always have duality. The lease should specify the services that the landlord is obliged to provide, and it should then permit the landlord to recover costs relevant to those services. 2 points to note with regard to that. Firstly, the courts don't like sweeping up provisions with regard to the recovery of costs. What they prefer to see is the parties agreeing a list of the sorts of services that they envisage, and then a provision in the lease that allows the landlord to recover those costs and those sorts of costs going forward. The second thing with regard to the service charge is that the lease will normally enable the landlord to transmit repair costs into service charge, repair costs for structure and common parts. The important thing to understand and appreciate is that the Building Safety Act 2022, and in particular Schedule 8, which applies to buildings over 11 metres or 5 stories in height, provides protection for leaseholders in Schedule 8 in connection with remediation works for relevant defects. So there may be service charge expenses being incurred relating to repair that fall outside the Act. So I go back to that first principle that I mentioned with regard to service charge. You've got to tell me as your client that I will be liable for whatever reasonable expenses the landlord incurs as the lease permits or as the lease specifies. Next thing to understand and appreciate is that the Building Safety Act, for the purposes of Schedule 8, leaseholder protection relating to service charge, applies to relevant buildings. And a relevant building is a building that exceeds 11 metres in height or contains more than 5 stories. As far as height of the building is concerned, the 11-metre height limit is to the top floor. So if a building has 6 floors and we're looking at 11 metres, not the number of stories, what we would do is measure to the top floor and the floor level, and that's our 11-metre height restraint. The second thing that the Building Safety Act does in connection with Schedule 8 protection relating to service charge is that it affords protection to qualifying leases. A qualifying lease, a lease that has a term in excess of 21 years, has a provision within it that obliges leaseholders to pay service charge, and was granted before the 14th of February 2022. So any lease that's granted after the 14th of February 2022 is not and cannot be protected by Schedule 8 of the Building Safety Act 2022. That said, the service charge provision within such a lease has certain relevance in connection with the Building Safety Act and is also subject to protection in that service charge must be reasonable, reasonable cost, reasonable work, subject to reasonable management. Landlords are obliged to consult with leaseholders where service charge costs exceed £250 per annum for one item of expenditure per leaseholder, or more than £200 per annum where that item of expenditure is to be incurred for more than 1 year. So there's protection with regard to that. There's also protection with regard to the 18-month rule, which I think is section 20Z of the Landlord and Tenant Act 1985. Service charge cannot be paid or cannot be demanded by a landlord where the landlord has incurred an expense but has not within 18 months provided the leaseholder with service charge accounts or notified the leaseholder that an expense has been incurred. And further, with regard to service charge, a landlord cannot demand service charge or insist on payment unless the landlord has served, along with the service charge demand, a notification as to the leaseholder's statutory rights to challenge service charge by way of application to first-tier tribunal. So important to understand all of that. As far as this slide is concerned, a number of points. Firstly, with regard to qualifying leases, remember we're talking about ownership or occupation as of the 14th of February 2022. The owner or occupier at that point must either have this flat or apartment and no other, or must have no more than 2 other flats or apartments in the United Kingdom in addition to this flat or apartment. The leaseholder that is able to confirm that they meet the criteria of the Act then has a qualifying lease as of the 14th of February 2022 and can issue a leaseholder deed of certificate to that end. And that leaseholder deed of certificate is then, as you like, a passport for future owners of that flat, meaning that they are afforded the protection under Schedule 8 of the Building Safety Act as a consequence. As far as landlord certificates are concerned, from a lease perspective, there's an important point. A landlord certificate should contain information from a landlord about remediation work that it is undertaking. And the landlord should be distinguishing remediation work that's caught by the Building Safety Act, in other words, remediation work for relevant defects, and work that is not within the Act in that it is not remediation work for relevant defects as defined. So the landlord certificate should specify work that the landlord is intending to do. 2 points. Firstly, it's important to check the lease to see that the lease enables the landlord or requires the landlord to do the work, and enables the landlord to transmit cost into service charge. The important point here is that, having explored most of the case law relevant to fire safety that has occurred over recent years, the courts have been quite prepared to say the work that needs to be done to comply with fire safety measures post-Grenfell has been work that landlords are entitled to charge for within the lease, either repairing obligations or compliance with statute or compliance with notices. Seems to get the landlord home to say, this is work that I need to do in accordance with the lease, and therefore I can transmit it into service charge. But the landlord certificate generates a new sort of document that needs to be produced where the landlord is undertaking works that are remediation works in connection with relevant defects as defined by the Act. The last point that I make on slide is something that's very important for everyone to be aware of today. Higher risk buildings, namely buildings that are more than 18 meters in height, impose a number of additional burdens on landlords. Firstly, the need for the building to be registered with the building safety regulator by the end of this month. Secondly, there are now terms implied into leases that are of dwellings within higher risk buildings. And those obligations are twofold: obligations on the landlord in connection with safety management, and obligations on leaseholders to not do anything to disrupt or disturb what the landlord is doing, and also to meet the landlord's cost that he or she incurs in the proper performance of their duties. These are called building safety charges. So with higher risk buildings, anything over 18 meters, it's essential that in addition to looking at the clauses in the lease itself, you also have a look at the implied terms that the Building Safety Act imply into the lease. The Act does that by amending the Landlord and Tenant Act 1985. The Building Safety Act is a very extensive piece of legislation. It isn't just looking at remediation costs in connection with relevant buildings. I've shown on slide here, it contains lots and lots of provisions, some of which are in law, some of which are now law, some of which are not. What we need to do is we need to have a look at sections 116 to 125 and remediation of certain defects. And when we talk about that, we need to understand what relevant defects are. So we need to understand and appreciate that a landlord might be obliged to carry out repairing obligations to comply with their statutory duties, to comply with notices, all of which could generate issues associated with repair. And all of those issues could, at the same time, constitute remediation to which the Building Safety Act applies. So what we need to do, I think, is we need to look at the LPE1 that a landlord produces, and to see if the landlord is highlighting any remediation work that needs to be done, and to ascertain if the landlord is saying that's within the BSA or without it. You do also need to watch out for LPE1s in that landlords might insert disclaimers in the LPE1 with regard to the information that they're producing or documents that they're annexing. The reason they're doing that is the Association of Residential Managing Agents has suggested that landlords could protect themselves by disclaimers in the LPE1. The LPE1 should have along with it a leaseholder deed of certificate and a landlord certificate. The landlord certificate is what I'm really interested in, to see what the landlord is doing or has done with regards to repair, and what sort of repairs they are, to determine whether or not Schedule 8 of the Act will afford protection for my leaseholder. It will also contain details of enforcement action the landlord is taking against third parties, or any action that is being taken against it. As I've mentioned already, the LP1 may contain some form of disclaimer. The next thing to understand is the TA7 form, which has now been revised and which is now in general circulation in connection with leasehold transactions. Section 11 of the TA7 now includes questions of the leaseholder concerning remediation work and other issues with regard to the Building Safety Act. So again, it's important to have a look at what the leaseholder is saying they are aware of with regard to remediation work. And again, I repeat the point, the landlord may be undertaking repair work that isn't in fact remediation that's caught by the Building Safety Act, in which case the standard service charge provisions within the lease and the statutory protection afforded to leaseholders would apply. If you're acting for a seller in connection with TA7 forms, I would always warn the client about the dangers of providing incorrect information and the risk of a misrepresentation action or a criminal offence under Section 2 of the Fraud Act being committed. And if you're acting for a buyer, I would say to the buyer client that, really the buyer should be relying on a survey of the building to determine whether or not what the leaseholder is saying, or indeed the landlord is saying in a landlord certificate, is correct. A leaseholder deed of certificate is in essence self-certification with regard to ownership and with regard to meeting the criteria to be a qualifying lease. The leaseholder deed of certificate is not going to assist in connection with whether or not work that the landlord is doing is remediation work as defined under the Act or otherwise. The leaseholder deed of certificate is, however, an important document that needs to be passed on to subsequent owners. Remember, the 14th of February is the key date for ownership, and the deed of certificate provides protection because if the leaseholder is able to meet the criteria required by the Act as of that date, then Schedule 8 of the Building Safety Act applies. A landlord certificate is going to do two things: give information about works the landlord is doing, and also confirming the financial status of the landlord. Where a landlord has free assets in excess of £2 million, then the Building Safety Act says if there is a relevant lease and a qualifying leaseholder, remediation work for relevant defects should be paid by the landlord out of their own funds. In other words, protecting leaseholders where landlords have sufficient assets to meet remediation costs. So the Building Safety Act has a number of practical issues. First of all, it's a huge bit of legislation that's very confusing. Secondly, it's not entirely in force. Thirdly, landlord certificates and leaseholder deeds of certificate are going to generate information that may be of use to leaseholders. You need to limit the scope of your retainer so the client understands the limits of your role with regard to the production or consideration of both of those documents. And with regard to fire safety regulations, again, it's important to understand and appreciate the Building Safety Act has not eradicated the need for EWS1s in certain circumstances and the need for special advice with regard to compliance with fire safety regs or remediation necessary for the compliance purposes. Other things that you need to watch out for are lender's instructions and risk to you in connection with claims. And to avoid that risk, what you need to do is limit the scope of your retainer and make sure the client understands in the report on title the limits that are sort of imposed on you with regard to advice concerning the Act. But the important thing I want you to get over today is the fact that, one, with higher risk buildings, we've got implied terms into residential leases. In any building, there is the potential for Building Safety Act issues arising, additional burdens, duties and responsibilities on landlords likely to increase service charge. And then we've got the Schedule 8 problem, the leaseholder landlord problem, leaseholder deed of certificate, landlord certificate problem, which applies to buildings that are more than 11 meters in height or which exceed 5 stories. So I want to just show you something before we finish today, which I think is important. The Building Safety Act refers to relevant defects in relevant buildings and provides that some remediation costs relating to some relevant defects are not payable by leaseholders that hold qualifying leases. So what is a relevant defect? A defect is a defect that arises where work was undertaken in the last 30 years which causes a building safety risk. And when we talk about a building safety risk, we talk about fire safety and we talk about risk of collapse. And we talk about risk, not just the leaseholders, but the safety of people in or about the building. So that would include visitors, contractors, even firefighters attending to deal with fires. So it's important to understand it's not just fire safety defects or fire safety remediation work. The second thing that we need to do is to understand what are relevant buildings, and Schedule 8 defines a relevant building, but the balance of the Act could potentially apply to any building that contains 2 or more residential units. So you could have a building that's in the majority commercial use, but nonetheless with 2 flats or apartments in it, then caught under the Building Safety Act 2022. So what is a relevant building? A self-contained building that contains at least 2 dwellings and is at least 11 meters high or contains 5 stories. So what's a qualifying lease? Well, there we go. Long lease of a single dwelling, tenant under the lease liable to pay service charge. So there must be an obligation to pay that charge. So again, when we're scrutinizing leases, it's important that we check, is there an obligation to pay service charge? If there is a lease that has a term of more than 21 years, then theoretically the Act could apply and Schedule 8 could apply if the lease was granted before the 14th of February 2022. This ownership occupation point that I mentioned at the bottom of the slide is an interesting one. And this is what's got a lot of practitioners really upset and concerned. How on earth can I, if I'm acting for a buyer, verify that what the seller is saying or what whoever produced the leaseholder deed of certificate is saying was the position with regard to ownership and occupation as of the 14th of February 2022. I would maintain that even if the seller is producing the leaseholder deed of certificate, in essence, the buyer is not going to be able to satisfy themselves that the seller is telling the truth with regard to condition D of section 117(2) of the Act. And here's where there's an important point for you. If we have a qualifying lease and if we have a relevant building, then there are limitations on the service charge that can be recoverable no matter what the lease says. If a landlord or associate is responsible for a relevant defect in a relevant building, then whether the lease is qualifying or not is irrelevant. The landlord cannot transmit cost into service charge. The thinking being the landlord did the work, the landlord should pay for remediation. If a landlord has free assets roughly in excess of £2 million, then the landlord doesn't meet the contribution condition and the landlord must meet the cost of remediation work for relevant defects. If leases have a value below £350,000 in Greater London, £175,000 outside of Greater London, then the landlord cannot recover remediation costs for relevant defects at all. If a service charge in connection with leases that exceed those values, if the service charge is below £15,000 in Greater London, £10,000 outside of Greater London, the landlord can recover those service charge costs for remediation work for relevant defects, but has to recover it over a 10-year period, meaning that leaseholders will pay £1,000 a year or £1,500 a year, depending on where the flat is located. In connection with cladding, as long as we've got a qualifying leaseholder, then the position is the landlord cannot charge for cladding remediation. So we're saved from works that the landlord did that now require remediation or cladding remediation, provided we have a relevant lease. For cladding remediation, sorry, a relevant building, for cladding remediation, we have to have a qualifying lease as well. Landlords can't recover legal or professional services relating to remediation where the lease is a qualifying lease and where the building is a relevant building. 2 important points. Again, when looking at residential leases, if the lease enables a landlord to borrow money, or if there's a reserve or sinking fund, the landlord cannot use either of those provisions in the lease to escape the protection that's afforded to leaseholders under Schedule 8. So the landlord can't say, oh, well, what I'll do is I'll just borrow money to pay for remediation costs. You're not allowed to do that. Schedule 8 in paragraph 10 restricts its use. And the other point is that where there is a reserve or sinking fund, it can't be used to meet remediation costs in connection with relevant defects. And this last point is important. Just because I'm a leaseholder that doesn't have a qualifying lease, does not mean the landlord can lump all the monies that he can't recover from other leaseholders into my service charge. So in other words, where leaseholders are protected under Schedule 8, the landlord either meets the cost itself or alternatively claims under a government scheme. This is important, and a lot of practitioners are not aware of it, and it's slightly off-piste, but I just thought I'd tell you it because I think it is so important. If you look at Schedule 8, paragraph 13 of the Building Safety Act 2022, it says, where you have a qualifying lease granted before the 14th of February, 21 years or more, containing an obligation to pay service charge, you don't have to worry about who was in ownership or occupation as of the 14th of February 2022, provided the landlord does not have a leaseholder deed of certificate from that leaseholder, and the landlord hasn't asked for it. And when we talk about asking for a leaseholder deed of certificate, the Act specifies that the landlord has not taken reasonable steps or prescribed steps to obtain the certificate. So if I'm acting in a transaction and I've got a situation where I've got a leaseholder deed of certificate, but I'm not happy about who owned or occupied the flat as of the 14th of February, if I can show the landlord doesn't have a leaseholder deed of certificate and hasn't asked for one, then my lease is a qualifying lease anyway. That's a very important point that some practitioners are overlooking. We've talked about that today, we've talked about that today and that today, and we've mentioned this proviso, this condition that enables us to escape ownership or occupation, which is so important. All I want to do now before I finish is just show you a few things. Firstly, the RICS in its professional standard for valuation, which was revised in December 2022, is saying to surveyors, don't in surveys or valuations confirm the height of a building or the number of stories, and don't confirm whether remediation work for relevant defects is being done or not being done. In other words, don't commit yourself to anything that could backfire in connection with the Building Safety Act. The next thing I want to talk about are lenders and the Building Safety Act. Watch out for lenders' instructions. Lenders are asking some firms to verify the content of a landlord certificate and a leaseholder deed of certificate. You can't. Both of these things will contain information that in the normal course of events, it will be difficult, if not impossible, for you to substantiate. Certainly with regard to landlord certificate, dealing with work concerning the property, remediation work or otherwise, and accountancy information about the landlord's financial status. I mentioned remediation schemes under the Act. There are 3 schemes. I don't know how much money is available in each. You tend to find that at some stage there will be funding, then it's used, then more funding is available. So it seems to be pretty much pot luck. If you look at a landlord certificate, the landlord should be telling you what remediation schemes are being claimed under, and you should also have that information also provided in connection with the LPE1. As far as fire safety is concerned, fire safety compliance under the Fire Safety Act or fire safety regulations, again, will normally be recovered by landlord within service charge. And the point that I think is important is where there is remediation work under the Act or under the regulations, that work will fall within remediation work as defined by the Building Safety Act. So the Building Safety Fire Safety Regulations 2022, which came into force on 23rd of January 2023, again, are likely to contain requirements on landlords to promote fire safety, and where a landlord is doing that work or meeting that liability, the costs that are being incurred will be incurred in service charge, but are likely to be remediation costs to which Schedule 8 applies. So, transactional issues. Should you act for sellers or buyers with regard to the Building Safety Act? I think you can safely act for sellers as long as the client is told that the leaseholder deed of certificate is produced by the client without any advice from you, in a sort of similar vein to what you're saying with regard to TA forms. I think with regard to a TA7, you do need to explain to a leaseholder seller what remediation work is, what a landlord certificate is, what a leaseholder deed of certificate is. You also need to have a think about previous remediation costs. Have there been any disclosures by the landlord about previous remediation, and has that remediation work been done? If a client produces a leaseholder deed of certificate or indeed a TA7 form and the information is defective or incorrect, your client could be liable for misrepresentation. Where your client has deliberately lied, then they will be potentially committing an offence under Section 2 of the Fraud Act 2006. So can your buyer rely on a landlord certificate or a leaseholder deed of certificate? Well, you can't rely on the content of the information, seems to be the current viewpoint. What's the protection of the Building Safety Act? It is protection under Schedule 8 for certain service charge costs relating to remediation for relevant defects. Other than that, I think what the Act does is provide practical protection for leaseholders, but it is likely to increase the service charge costs that leaseholders are going to have to pay, in particular with regard to higher risk buildings. The Act does not apply if a building or lease is non-qualifying. It doesn't apply if a leaseholder deed of certificate is not produced or available, and it doesn't apply if leaseholders own the superior title. Where they're managing the building courtesy of right to manage, that's fine, but the moment they've collectively enfranchised or they own the superior title, the Building Safety Act doesn't apply, and of course it doesn't apply to leases granted after the 14th of February 2022. Does the Act increase the risk of leaseholder insolvency? Probably not. Does it increase the risk of landlord insolvency? Definitely, in my view. What I'm going to do now is open up the room to questions. So can we have a look if there are any questions in the Q&A, or if anyone has any comments in chat? Again, I repeat the need to be cautious in connection with leasehold work. Make sure that you don't just provide the client with a copy of the lease, but provide the client with an explanation of the terms of the lease and put that into context, I think is the key issue. So does anyone have any questions or queries? I'm just looking in the chat facility, Helen, and I don't have anything showing at the moment or in the Q&A.
Not clear to me either, but let's see that we are at a time, but as you mentioned at the start, you're very welcome to follow up with you afterwards. And that in that case, I would say thank you very much again, Ian, for talking. Informative as ever. You squeeze a lot of the time available.
Yes.
And goodbye, everyone.
Thank you. Bye-bye. Stay safe. Do drop me a note if you have any questions. Thanks, Martin. Bye-bye. Thanks, Helen.